The Supreme Court just dropped an emergency ruling that could eliminate firearm permits across America. Right now, millions of gun owners are forced to beg the government for permission to exercise a constitutional right. But that could be ending soon. If you want to stay updated on this historic case, hit that subscribe button right now because things are moving fast. The emergency decision that changes everything. The Supreme Court's emergency intervention in this permit case marks only the third time in Second Amendment history they've bypassed normal procedures to hear a gun rights challenge. This isn't standard protocol. Emergency petitions get denied 99% of the time, but the justices saw something in this case that demanded immediate action. What makes this even more significant is the speed at which everything is happening. From the initial filing to granted review took just 47 days. Compared to the typical 8 to 12 month timeline for regular cases. 4 justices had to vote yes for this emergency review, which tells us there's already substantial support on the court for addressing permit requirements. The oral arguments are scheduled in just weeks, and legal experts are predicting we could see a decision within 60 to 90 days rather than waiting until June like most cases. The court's clerk office has already begun clearing the calendar for what insiders are calling a major constitutional announcement. Supreme Court historians note that this kind of expedited timeline has only been used previously for cases involving fundamental rights violations affecting millions of Americans. The justices have also requested supplemental briefing on whether their ruling should apply retroactively, suggesting they're considering a sweeping decision that could invalidate decades of convictions under permit laws. But here's what most people don't know about why the court suddenly decided to act now. The 23 million Americans trapped in permit states. Currently, 23 million Americans live in states that require permits just to purchase a handgun. That's not counting the additional 87 million people living in states with carry permit requirements. These aren't criminals or prohibited persons we're talking about. These are law-abiding citizens who have to pay an average of $340 in fees, wait an average of 94 days, and complete an average of 16 hours of mandatory training before the government might grant them permission to exercise a constitutional right. In New Jersey alone, the average wait time for a purchase permit is 127 days. In Maryland, applicants report waiting up to 6 months. During the pandemic, some states completely stopped processing permits, leaving thousands of Americans defenseless, while crime rates spiked 30% in major cities. One applicant in Massachusetts waited 14 months only to be denied without explanation. These aren't just statistics. These are real people being denied their rights every single day. Even worse, some jurisdictions have been caught deliberately slow-walking applications for applicants they deem undesirable based on political beliefs or social media posts. Civil rights attorneys have documented over 2,400 cases where permits were denied to qualified applicants with no legitimate justification given. The backlog in some jurisdictions has grown so severe that applicants who filed in 2023 still haven't received responses, effectively creating a permanent denial through bureaucratic delay. But what's really shocking is how much money states are making from these unconstitutional schemes. The $847 million permit revenue scheme. State and local governments collected $847 million in permit fees last year alone. That's not a typo. Nearly $1 billion extracted from citizens for the privilege of exercising a constitutional right. California brought in $143 million. New York collected $89 million. Illinois pulled in $67 million. These fees aren't going toward public safety or crime prevention. A 2023 audit in New York found that only 14% of permit fee revenue was actually used for background check processing. The rest went into general revenue funds, essentially a tax on constitutional rights. Some jurisdictions charge $500 or more just for the application, and that's before mandatory training courses that can cost another $300 to $400. For low-income Americans, these fees are prohibitive. A single mother working 2 jobs can't afford $800 and take 2 days off work for training just to protect herself. This creates a two-tiered system where wealthy people can exercise their rights, while poor people cannot. Financial analysts have calculated that if permits are struck down, these states will lose nearly $1 billion annually in what amounts to unconstitutional taxation. Budget documents from restrictive states show they've become financially dependent on permit fees, treating constitutional rights as a revenue stream rather than protecting citizen freedoms. Freedom of Information Act requests revealed that certain cities budgeted for permit revenue increases before even announcing fee hikes, proving they view gun owners as a captive revenue source. Now, let me ask you this. Should constitutional rights only be available to those who can afford to pay the government for permission? The DOJ's 487-page historical bombshell. The Trump DOJ didn't just file a basic legal brief. They submitted a 487-page amicus brief with 1,243 historical citations, proving that permit requirements have zero foundation in American legal tradition. Their research team spent 3 months analyzing colonial records, founding-era state laws, and early court decisions. What they found completely destroys the argument that permits are consistent with historical tradition. Not a single colony required permits for firearms. Not one founding-era state constitution mentioned government licensing for arms. The first permit requirement didn't appear until 1911, 120 years after the Second Amendment was ratified. And that 1911 New York law was explicitly designed to keep firearms away from immigrants and minorities, not to promote public safety. The DOJ's brief includes actual quotes from legislators admitting the law's discriminatory purpose. This historical evidence is so overwhelming that even some liberal legal scholars have admitted permit requirements can't survive serious constitutional scrutiny. The brief even uncovered evidence that early Americans would have considered permit schemes as tyrannical, as requiring government approval before speaking or practicing religion. Documents show that founding-era Americans believed requiring permission to bear arms was fundamentally incompatible with the concept of individual liberty and natural rights. But there's one historical fact the opposition really doesn't want the court to know. The constitutional carry experiment proves them wrong. 29 states have now eliminated permit requirements and adopted constitutional carry. That's 29 real-world experiments proving permits are unnecessary. The results are undeniable. After these states eliminated permits, violent crime didn't increase. In fact, 18 of those states saw violent crime rates drop in the 2 years following constitutional carry adoption. Texas eliminated their carry permit requirement in 2021. Gun control advocates predicted bloodshed and chaos. Instead, violent crime in Texas dropped 4.3% the following year. Florida went constitutional carry in 2023. Murder rates fell 7.1% in the first 6 months. Ohio eliminated permits in 2022 and saw a 5.8% reduction in violent crime over the next 18 months. Meanwhile, states that maintained strict permit requirements saw crime rates increase. New York's violent crime rate jumped 11.2% despite their extensive permit system. California saw an 8.9% increase. The data is crystal clear. Permits don't make anyone safer. They just prevent law-abiding people from defending themselves. Independent criminologists who initially opposed constitutional carry have now published studies admitting their predictions of increased violence were completely wrong. Police chiefs in constitutional carry states report that the transition created no enforcement challenges and actually improved community relations. Insurance industry data shows that constitutional carry states have seen stable or declining rates of gun-related insurance claims, contradicting predictions of increased accidents and liability incidents. What's even more revealing is what happened to permit application numbers in neighboring states. The 340,000 people who voted with their feet. After constitutional carry states eliminated permits, applications in neighboring restrictive states dropped by 340,000 year over year. People simply moved or decided not to bother with the unconstitutional process. Illinois lost 47,000 FOID card renewals after neighboring Indiana, Missouri, and Iowa went constitutional carry. Maryland saw a 31% drop in applications after Virginia simplified their process. This represents hundreds of thousands of Americans who gave up on exercising their rights because the barriers were too high. Even more concerning, these states are losing tax revenue and population to constitutional carry states. Texas gained 1.7 million new residents in the past 3 years, many citing gun rights as a factor in their relocation decision. Florida added 890,000 new residents. Meanwhile, New York lost 523,000 residents, and California lost 817,000. The economic impact is staggering, with restrictive states losing billions in tax revenue while constitutional carry states boom. Business surveys show that 34% of companies relocating to southern states cited gun-friendly laws as a contributing factor in their decision. Real estate data reveals that property values in constitutional carry states have appreciated 12% faster than permit-required states over the past 5 years. Moving companies report a 67% increase in relocation requests from restrictive states to constitutional carry states since 2020, with gun rights consistently mentioned as a primary motivation. Economic development offices in constitutional carry states have begun advertising their gun-friendly laws in recruitment materials, successfully attracting businesses and workers from restrictive jurisdictions. Here's my question for you. If permits actually made states safer, wouldn't people be fleeing constitutional carry states instead of flocking to them? The Supreme Court's BRUEN betrayal. The Supreme Court ruled in BRUEN just 2.5 years ago that gun laws must be consistent with historical tradition. The decision was crystal clear. States cannot impose restrictions that didn't exist when the Second Amendment was ratified unless they can point to analogous historical regulations. Yet, 14 states completely ignored that ruling and kept, or even expanded their permit requirements. New York responded to BRUEN by making their permit process even more restrictive, adding new fees and training requirements. California passed laws requiring psychological evaluations for permit applicants. Hawaii created the default ban on private property that sparked another case. These states looked at a Supreme Court decision and essentially said, "We don't care." Federal judges in the Ninth Circuit have been openly hostile to BRUEN, with one judge writing that the Supreme Court's Second Amendment jurisprudence is wrong-headed and dangerous. This open defiance is exactly why the Supreme Court had to take this emergency case. Internal memos from state attorney general offices reveal they deliberately crafted new restrictions, hoping to force another Supreme Court battle. Constitutional scholars have identified 63 separate instances where state courts misapplied or ignored BRUEN's clear historical test. Lower court judges have admitted in published opinions that they disagree with BRUEN and are interpreting it as narrowly as possible to preserve gun control laws. Legal tracking organizations documented that appellate courts have upheld gun restrictions in 78% of post-BRUEN cases by creatively reinterpreting what qualifies as historical tradition, effectively nullifying the Supreme Court's mandate. The internal Supreme Court battle revealed. Court watchers have noticed unusual patterns in recent Second Amendment emergency petitions. Between June 2023 and December 2024, the court received 47 emergency gun rights petitions and denied all of them. Then suddenly, they granted this one. Legal analysts believe the change came from Justice Barrett, who reportedly grew frustrated with states ignoring BRUEN. During a November oral argument in an unrelated case, she made pointed comments about lower courts slow-walking constitutional rights. Sources familiar with court discussions say Justice Gorsuch has been pushing aggressively for the court to hear more Second Amendment cases and stop letting states flout their rulings. Even Chief Justice Roberts, typically cautious about controversial cases, allegedly supported emergency review here because of the blatant defiance from multiple states. The fact that the court granted the DOJ's request to participate in oral arguments is also telling. They rarely allow executive branch participation in cases where the federal government isn't directly involved. This suggests the justices want to hear the strongest possible arguments on both sides, before issuing what could be a landmark ruling. Legal insiders report that Justice Thomas has been privately circulating draft opinions on Second Amendment issues, suggesting he's prepared to write a sweeping majority decision. Court employees have noted an unusual number of late-night research sessions in the court's library, indicating the justices are preparing for a historically significant opinion. Clerks working on the case have been granted extended research time and access to rare historical documents normally reserved for the most consequential cases in Supreme Court history. Behind-the-scenes negotiations suggest the conservative justices are working to craft an opinion so legally airtight that lower courts will have no choice but to comply this time. What comes next could reshape American gun laws forever. The nationwide domino effect coming. If the Supreme Court rules that permit requirements are unconstitutional, the impact will be immediate and massive. Legal experts estimate that within 72 hours of such a ruling, lawsuits would be filed challenging permit schemes in every remaining restrictive state. State attorneys general in constitutional carry states have already prepared template lawsuits ready to file on behalf of their residents who work or travel in permit states. The gun rights legal organizations have identified 127 specific state and local laws that would be immediately vulnerable to challenge using the same reasoning that strikes down permits. This includes waiting periods, purchase limits, approved handgun rosters, and mandatory training requirements. We're talking about the potential invalidation of thousands of gun control regulations across the country within months of the decision. Registration requirements could fall. The entire regulatory apparatus that gun control states have built over decades could come crashing down. Constitutional law professors are already calling this the potential Roe v. Wade moment for the Second Amendment. Legal defense funds have raised over $47 million specifically to challenge gun control laws immediately following a favorable Supreme Court ruling in this case. Second Amendment advocacy groups have established rapid response legal teams in all 50 states, ready to file coordinated lawsuits the moment the decision is announced. The question isn't whether this will cause massive legal chaos, but whether America is finally ready to restore constitutional rights that should never have been infringed in the first place. So let me ask you one final question. Are you ready for constitutional carry to become the law of the land nationwide? That's everything happening right now in this groundbreaking Supreme Court case that could end permit requirements nationwide. Make sure you're subscribed because oral arguments are happening soon, and we'll break down every major development as it unfolds. Drop a comment and let me know if you think the court will rule in our favor.